social worker at the detention center. The social worker will help them walk through the process, make sure all the child's needs are being met, and give them direction as to where they're supposed to be and when, and generally some direction about where they're supposed to be in court and at what time.
Now, you're using the term very specifically. You're saying detention center. It's not jail.
That's right. According to New Jersey's laws, children under the age of 18 cannot go to a jail. They have to go to an approved detention center, approved by the Department of Justice, the Division of Corrections. It cannot be a jail. We don't want to put juveniles in the same facility as adults, for obvious reasons.
Well, what about at the police station itself? When they're taken into custody, can they go into a holding cell with adults?
They can go into a holding cell, but not with adults. As a matter of fact, they're not even supposed to be exposed to adults. So if you had two holding cells right next to each other, they're not supposed to be put in a holding cell right next to adults where they could be harassed or bothered, etc.
Okay, so we have left off with going before a judge the next morning, and then a detention hearing?
That's right. They call this the initial detention hearing. Sometimes at this point, the parents have already been able to obtain counsel. They've had a chance to discuss the issues with the counsel, and the attorneys will try to make provisions for his or her release. The purpose is to make sure that a complaint has been filed and where the child is going to be. If a complaint has not been filed, the law requires that the juvenile be released immediately. So he cannot be held or she cannot be held unless there's been a complaint filed. If a complaint has been filed, then the court needs to determine should the juvenile be released or should the juvenile be remanded to the detention center.
So let's explore this a little bit. Two things. One, who files the complaint that you're talking about? And let's explain what it means to be remanded in case some people are not familiar with the term.
Anybody can file a complaint against a juvenile. It can be a citizen's complaint or it can be a complaint filed by the police. If it's a citizen's complaint, it's not likely that we're discussing whether or not the juvenile should be remanded or sent to the detention center. If it's serious enough that a juvenile is facing detention, then it would probably be a complaint filed by the police. Once that complaint is filed, the juvenile and his or her parents have to be served with the complaint because due process mandates that they be notified of what they're accused of so that they can prepare and respond to it.
When you talk about these charges, just to be clear, we're always talking about criminal issues, right?
That's correct.
So if there's a baseball that goes flying through a window and it's a civil matter, a matter where somebody wants to complain and get money to fix their window, but really doesn't think there's any criminal activity involved, none of this applies?
That's right. None of this applies. Juveniles in juvenile delinquency actions have to be accused of a crime or an offense. Motor vehicle offenses, for example, are handled in municipal court. So if your teenager is accused of speeding or driving without auto insurance or driving while intoxicated, that would be heard in the municipal court.
Why would that not go to the family court as the other juvenile matters would?
Because the statutes say there's not so much of a focus on rehabilitation. There's more of a focus of a violation, fixing the violation and dealing with it in municipal court, as opposed to the theory of rehabilitation, that there may be broader issues than the act itself in family court.
Are there any crimes or offenses that would carry a penalty for you and I that juveniles are free to and just they get a pass?
No.
No.
There are the same defenses for juveniles as there are for adults. There are the same crimes for juveniles as there are for adults. There are the same rights for juveniles as there are for adults. For example, the right to an attorney, the right to confront your accuser, the right to have a trial. The rights are all the same. It's just the procedure that's a little different for juveniles as compared to adults.
When we go back to our hypothetical, we have visited with the judge. Sadly, the judge says you have to be detained. How long can the detention last prior to an actual trial being concluded?
Well, first the court has to determine whether or not you're being detained. So let me address that first, and then I'll get back to how long. The court has to look at a number of factors, and they have to look at whether or not the juvenile is over the age of 11. because children under the age of 11, we're going to hold them to a higher standard. In other words, it has to be a first or second degree crime or an arson for someone under 11 to be detained.
So they're going to be held to a lesser standard.
I'm sorry, a lesser standard, a higher crime is what I meant to say.
I see.
Children over the age of 11, they have to be accused of a crime. Now, there's two levels of crimes in New Jersey. There's crimes and offenses. Offenses for adults are heard in the municipal court. If a juvenile is heard of a single offense, it's not likely that they're going to be detained. If they're accused of a crime, like an aggravated assault or a burglary, like you said, then the court has to weigh certain factors. They have to weigh whether or not the juvenile is in any danger, whether or not another person is at risk of injury, whether their safety is threatened, or whether someone's personal property is seriously threatened. Not just threatened, but seriously threatened. The other reason a judge could remand someone to the detention center is if they are concerned that the juvenile might not return to court. And they can base that decision on a prior history. If the juvenile has a prior history of failing to appear in court, or failing to report to the probation officer, or failing to report to a counselor, let's say, then the judge can take that into consideration when trying to determine whether or not they should be remanded to detention or whether or not they should be released under other circumstances.
Do we have ankle bracelets and such here in the state?
There are other alternatives. One of those is the electronic monitoring. That's typically done through a program, and that program also consists of counseling. But there is ankle bracelets in some counties, not all. The way that this works is they install something in your house that's roughly the size of a fax machine. And the fax machine type of box can keep track of how far the signal from the ankle bracelet is from the box. If you exceed a certain distance, it can go off. So for example, I had a case once where a juvenile was outside playing basketball. He had the ankle bracelet on. The basketball got away from him and rolled down the street. The machine notified the police that he had broken the perimeter.
Right.
He went back to playing basketball, and the police showed up accusing him of leaving the area. Once we were able to piece it together, we realized what happened. There are other options too. The court can release a juvenile home on house arrest, which means that home is his jail. Generally, you can be in the backyard of your house, but your parents are your guardians. So you cannot leave your home without your parents. If they want to take you to the food store, if they want to take you out for dinner, they want to take you to church, you can do those things as long as you're with your parents.
So you have to be in their company.
You have to always be in their company if you're home on house arrest. The court can just release you again without being on house arrest, without being on an ankle bracelet. Those are just other alternatives to detention.
So let's go through the mock trial in our time remaining. And the same defenses, the same rights apply to juveniles as to adults, you said.
Absolutely, that's right.
So, right to confront the accuser. A right to remain silent. The juvenile does not have to testify.
Correct.
If a juvenile does testify and is under the age of 11, is there some thought that the court gives to the education or to the mental competency? Strike mental competency, just the psychological development of a young child, which is different than an adult.
Absolutely. I had a 7-year-old child that was accused of a crime. And the issue became whether or not the juvenile was competent to understand where he was and the position that he was in. Did he understand the role of the judge? Did he understand the role of the prosecutor? Did he understand what it meant to be accused of a crime? Essentially, the court had determined that the juvenile did not because he was only 7 years old. And so the case was dismissed in this particular instance without prejudice, meaning that it could come back later on in the future. It never did. That was about 10 years ago. But that, I think, illustrates your question. The court takes special care to protect juveniles.
That is illustrative of what I'm talking about, and I'm thinking that the audience might be interested in knowing, is there an age? To say, well, you said 11 years and older, you're held to a higher standard than 11 years and under. Does that mean 8, 9, and 10-year-olds can just go about and
No. Like I said, I had a 7-year-old who was prosecuted. I think the standard, the test, is the age of reason. When can a child reason between right and wrong? Do they know that they're committing a crime and do it intentionally? Because again, to commit a criminal offense, you have to have the intention to do it. It can't be a mistake. It can't be an accident. You have to have an intention to do it. There are certain circumstances for reckless behavior. For example, drag racing could be a crime. The stereotypical example of kids racing in a car and somebody dies